Today I'm going to be talking about why euthanasia or assisted suicide should be an option given to patients with terminal illness or with no hope of recovering, such as those in a persistent vegetative state. These reasons include people should be able to choose their own end-of-life measures, the right to die protected by the Constitution, and the way the physician role changes as the diagnosis progresses. My first point is that people should be able to choose their own end-of-life measures. This privacy is protected by the Constitution. In the Fourth Amendment, where the right to privacy states that people should be secure in themselves and their households, which also alludes to the idea that personal choices can't be judged or scrutinized because other people do not agree with it. Lastly, the medical practice of judicial neglect, which is when the medical professionals start treating and acting in the best interest of their patient. Sandra S. Klein, a librarian at the Notre Dame Law School, published an article on the Notre Dame Law School's website, which included a quote that says, "Individuals do possess a right to purposely choose death," which essentially means that underneath the Constitution, people do have a right to choose to end their own life in a medical sense if that's what they see fit. Next, the right to die. This is protected by personal freedoms and rights and is also a part of the right to privacy under the Constitution. Things such as living wills and advance directives can be made while a person is still in a healthy and competent state to prevent them from having any confusion when it comes to the time to make these harsh decisions. Lastly, the Due Process Clause. On FindLaw.com, it discusses the Cruzan versus Director, Missouri Department of Health case, in which the Supreme Court ruled that the Due Process Clause does protect a person's liberty to refuse treatment, which means that a person does reserve the right to say no to certain treatments or to any unnecessary measures, which goes hand in hand with the living wills and advance directives, because people could say they don't want to be placed on ventilators, or people can put in place DNRs, do not resuscitate, so that if their heart does stop beating, they aren't brought back to life. Lastly, the physician role changes. It's unethical to force a person to live in agony when there's no hope of them getting better. Secondly, no unnecessary measures should be taken if that's not what the person wants, which is why the living will should be put into place in situations when there's a terminally ill patient. And it could also help in pretty much all cases, because if someone does randomly enter a persistent vegetative state, their choices will have already been set in stone, and so there can be no argument regarding these choices. One popular case about the no unnecessary measures is the Terry Schiavo case. She entered a permanent vegetative state at a very young age and never recovered from it. There was a lot of argument between her husband and her parents about whether or not these life-sustaining measures should be continued on. Eventually, the courts ruled in her husband's favor and stated that since he was her husband, he was the one who would be making decisions for her at this time. An article on NNDB.com had quotes from the medical examiner who did Terry's autopsy. The examiner stated that Terry's brain weighed half of what the normal human brain should weigh, and that no amount of treatment or therapy would have helped at this point. There would have been no way to get her back to functioning as a normal human should. In conclusion, I believe that euthanasia or assisted suicide should be an option given to patients with no hope of ever recovering, because people deserve the right to choose their own end-of-life measures. They have the right to die as protected by the Constitution, and the physician role should change to be acting in the best interest of the patient and with aligning the ideas of the patient. Thank you.